Hi, everyone. Welcome to our webinar, Going Viral, Navigating Civil Rights, Free Speech, and Social Media in Campus Contexts. I'm Rafa Shams, Director of Communications and Programming at AEN, and I'm very pleased that you are joining us today. This is a very timely topic. As we know, social media posts by faculty, students, and campus organizations have caused controversy and raised questions about the limits of free speech, raised questions such as under what circumstances can social media posts violate the law or campus policy, particularly with regard to the civil rights of others. What implications do these issues have on the effort to counter anti-Semitism on campus and to advance the civil rights of Jewish students and faculty and all students and faculty? How can university administrations develop guidelines on social media usage that both protect free speech and academic freedom and the civil rights of all members of the campus community? This is more relevant than ever. Just in the last few weeks, with the outbreak of hostilities between the US and Israel and Iran, we've seen incendiary posts by individuals and organizations at different campuses promoting conspiracies, glorifying and celebrating violence, supporting extremism. How do we navigate such a challenging terrain? While AEN's webinars are usually limited to faculty and select partners, we thought this would be very relevant for administrators as well as they seek to understand the on-the-ground and virtual realities. Our webinar will feature two eminent legal scholars, Leslie Tenzer and Matt Nasanchuk, who will explore these questions and more. We're very grateful to have them with us today to share their expertise. A Q&A will follow their conversation. So I'd like to get started with our guests now. I ask that you please hold your questions for the Q&A afterwards. You can use the raised hand emoji or type your question into the chat. Just to briefly introduce Leslie Tenzer, she is a professor of law and semi-centennial faculty scholar at the Elizabeth Haub School of Law at Pace University. Her scholarship and teaching bridge the worlds of theory and practice with a particular focus on regulating conduct in the digital age. Her most recent scholarship focuses on legal issues concerning social media. She is the faculty advisor to the Pace Law Review and host of two popular podcasts for students. And now I'm going to turn it over to my colleague, Steph Wapner, who directs our administrator programming, to talk a little bit about how this is relevant for administrators and to introduce Matt.
Hi, everyone. So great to see you all here. At a time when anti-Semitism is spreading rapidly through social media, higher education leaders are navigating uniquely complex questions about free speech, student safety, and institutional responsibility. Our speakers today bring a uniquely informed perspective on how administrators can uphold core principles of open expression while also addressing the real harms caused by online hate as it disseminates through campuses. And it makes their insights especially relevant for those who are involved in shaping today's campus climate. Our other speaker today is Matt Nosanchuk. Matt serves as the principal of Matt No Strategies and is also, as of very recently, the Lerner Family Associate Dean for Public Interest and Public Service Law at George Washington University Law School. He leads efforts to combat anti-Semitism and advance civil rights through legal advocacy, education, and policy. He previously served in the White House as an associate director of public engagement, where he was the administration's primary liaison to the American Jewish community and a key advisor on issues of anti-Semitism and religious freedom. Earlier in his career, Matt worked at the U.S. Department of Justice and in private practice, building expertise at the intersection of law, public policy, and civil rights. Matt and Leslie, we're so pleased to have you with us today. Thank you for sharing your time.
Thank you for having us and for the warm introduction. Hello. So this is about social media law, and we're lucky to have Matt here, who is an expert on Title VI. But I wanted to frame the conversation, and I want to frame it by beginning with a social media post that happened at our school, where a student in this September on 9/11, posted the two World Trade Centers burning with the caption, "Who caused 9/11?" and a series of juice boxes. I did not know that juice boxes is a derogatory word or slang for Jews, but my students did, and they brought that to the attention to my attention, and then we brought it to the administration's attention. So being a law school, we were particularly concerned with the students' First Amendment rights, and that First Amendment right kind of butts up to Title VI. So what I'd like to do, just to kind of frame the conversation, is give you a down and dirty, quick First Amendment right overview for campus speech. The Supreme Court has really only heard two cases on campus speech. The first was 50 years ago, which was Tinker versus Des Moines. And what happened in Tinker versus Des Moines was that three students during the Vietnam War wore black armbands to protest the war. The students were promptly suspended, and the students appealed, arguing that their First Amendment rights were violated. And in that case, the Supreme Court said that a student's First Amendment rights do not stop at the school steps, but instead the students do have a protected First Amendment right so long as what they're doing does not materially disrupt schoolwork or involve substantial disruption in the classroom. 50 years later, the court was faced with its second decision. This decision actually happened during COVID when a lot of students were doing remote learning. But what happened was in Mahanoy versus BL, Mahanoy School District, I should say, versus BL. BL was off campus. She did not make a sports team, and she posted something off campus that said basically, pardon my language, but I'm going to use it. Fuck the school, fuck softball, fuck cheer, fuck everything. That made it onto campus, and the campus promptly suspended her. And like the students in Tinker, she appealed and the suspension and brought a case for First Amendment. And the Supreme Court in that case basically just said Tinker stands. And they said something that I think is of particular interest today, which is they said in the decision, when political or religious speech is involved, we must respect an interest in protecting student unpopular expression. So that's where that stood. Now, one last case I want to tell you about happened most recently, and that happened in Colorado in the 10th Circuit. And it is called C1G versus Siegfried. And what happened was CG went to a kind of Army Navy store and with a bunch of boys, and they took a picture while they were wearing World War II style hats. And on top of it, CG wrote, "Me and the boys about to exterminate Jews." Well, this made it to the campus. I made it to this school, and this is a particularly Jewish or heavily populated Jewish community in Colorado. He was suspended and actually threatened with expulsion, and his family appealed. And basically, what the court said in that case is, we are bound by Tinker, we are bound by Mahanoy, and so unless there is a substantial concern, or substantial disruption in the school, we cannot infringe on someone's First Amendment rights. Now, to be fair, these cases really are all K through 12, and we don't really have cases that per se deal with posts or speech outside of class, making it onto the classroom. We obviously have some cases, some are pending, some have been decided, about speech in terms of the encampments, but not really social media posts. And so this is what we're left with. But while the First Amendment broadly protects the offensive speech of these students, Title VI offers a competing framework, one which brings us the topic of today's discussion, which is what extent do we use Title VI, and to what extent is Title VI available to protect students on campus for harmful social media posts? And that's where I'm going to ask our esteemed colleague Matt to kind of give us a discussion and explanation, and I look forward to him unpacking all of this. And Matt, I'll ask you kind of the easy question first, which is, as an administrator, if the administrator was brought to if the social media post was brought to the attention of the administrator, what would you suggest the administrator do in terms of bringing a Title VI claim?
Right. Yeah. So thank you, Leslie, for the question, and thanks to Stephanie and to AEN for the opportunity to meet with all of you today. I really appreciate the chance to speak with you about these challenging issues at the intersection of the First Amendment and Title VI. So, with respect to Title VI, Title VI, provides that no person shall be on the basis of race, color, national origin, excluded from participation or denied the benefits, or subjected to any program to which Title VI applies. And basically, Title VI is holding schools accountable under the law to provide equal educational opportunity to all students. And Title VI has been interpreted through a series of cases and executive branch interpretations over the years to apply to anti-Semitic discrimination, not on the basis of religious discrimination, but on the basis of what we call shared ancestry or ethnicity, their actual or perceived ancestry or ethnic characteristics. And that includes students of Jewish, Palestinian, Muslim, Arab, Israeli, South Asian origin. And to establish and so under the Title VI framework, if a student feels that they have been discriminated against on the basis of their Jewish identity, then they can, bring a complaint to their school's, Title VI office or, equal opportunity office, or, file a complaint with OCR, or in some instances, lawsuits are applied where lawsuits are filed and a violation of Title VI is alleged, which essentially means that the school has failed to fulfill its responsibility to ensure an environment that's non-discriminatory for these students. And it typically does not apply, to every single instance of discrimination or anti-Semitic discrimination that occurs, but it applies when there is a demonstrated hostile environment. In other words, there has been instances of discrimination that are severe or pervasive and that are offensive both subjectively to the student and objectively for someone looking at the situation to determine whether discrimination has occurred. And then the question is whether the school has responded and taken a prompt and effective action to cure the discrimination. And so that's the Title VI framework that exists, and it has been, and it does apply in the context of social media posts. And I think what Leslie described in terms of the secondary schools, K through 12 schools, where Tinker and Mahoney arose. I mean, there are instances in higher education where social media posts have been a feature of the anti-discrimination, anti-Semitic discrimination that has occurred and been alleged. And we can talk more about those instances and how they fit into the Title VI framework.
Well, I mean, and that's actually a great question to go with. I guess one of the questions to your point is, what would make a discriminatory social media post such that it would make people feel uncomfortable on campus? Like, we talked about this idea of juice boxes, and we didn't really know what juice boxes meant, some of us. We've talked about posting watermelons. I mean, is there kind of a threshold of proof required to say that this makes someone feel uncomfortable on campus, or is it more of a subjective evaluation?
Yeah, I mean, I think for purposes of Title VI, the challenge that we encountered in the post-October 7th environment in the Department of Education was a challenge around the offensiveness of the First Amendment protected activity, and whether that offensive protected activity could be considered in the context of determining whether a civil rights violation had occurred. And I think the misconception that exists is that, if there's First Amendment protected activity, then it cannot be considered in determining whether there's been a violation of Title VI. And that's not the law, and that's not how we interpreted the law. Now, that doesn't mean that there are, necessarily super clear lines, but you can have speech that is protected by the First Amendment, but if it is contributing to the creation of a hostile environment, if it's one evidentiary factor in determining overall that there's been a hostile environment and it has impacted students in a significant way such that their ability to access educational opportunities on an equal basis with other students has been impacted, then it can arise, then Title VI concerns can arise. And so, we in the Office for Civil Rights, we were enforcing the civil rights laws. We were not enforcing the First Amendment. However, any resolution of discrimination allegations would necessarily have to comply with the First Amendment. So the answer isn't, well, we need to censor speech. The answer is to have, neutral time, place, and manner restrictions or other policies that don't evince viewpoint discrimination in determining how best to respond to the offensive speech that has occurred. I mean, a single instance, a single post of the nature that you described, Leslie, that's, a general statement of a political position around Israel and Palestine, you would need to have more evidence that that particular post had a level of severity or pervasiveness and that it was significantly impacting individual students' own experience of anti-Semitic discrimination in their school.
So, I'm not a Title VI expert and you are, so I'm going to ask you a question and apologies if this is kind of too basic, but I think about my students on campus and the students who brought this social media post to my attention and we have a healthy number of Jewish students on campus. Some don't even identify as Jewish. Some find, the slightest bit of suggestion of anti-Semitism, incredibly upsetting and interrupting in their services, their ability to learn. So I guess what creates, you said that one social media post itself may not create a hostile environment. What would create a hostile environment that impacts students? And to what extent is this a subjective evaluation versus an objective? I mean, I know we're always going to end up in the courts and they're going to decide it, but, there's something in tort, which is the eggshell plaintiff. You take your plaintiff as you find him. And I'm wondering, to what extent do a student's sensitivities play into creating a Title VI action?
Right. So the standard is that it's subjectively and objectively offensive. So, the eggshell student, who has a strong subjective reaction to the anti-Semitic speech, their experience is not enough on its own. I mean, there is also this objective test. So there has to be a determination whether it is also objectively offensive to the reasonable observer. So it requires both, and and the way in which there is a determination made that there's a hostile environment that exists is that OCR, when it would conduct an investigation, would look to see how individual students were being impacted. In other words, has the speech been in some sense targeted at them? I mean, doesn't necessarily have to be targeted in the sense that it's a true threat, right? So if it's a true threat under the First Amendment, then it's not protected. But here, the speech that can be problematic can be protected, but it is targeted and that it is contributing to the existence of a hostile environment. And, that's understood once there are interactions with those students who have been affected, and they're talking about, the fact that they're, avoiding going to certain parts of campus, or they're skipping classes, or they're feeling, so depressed that they're, staying in their dorm room, or they're ceasing to do extracurricular activities. Like the determination of the existence of hostile environment has to be determined based on understanding how students have been impacted by the discrimination that they have experienced and say is occurring.
Is that a heavy burden? I mean, how successful do you think someone would be, or how successful would a school be? And I do want to point out, someone pointed out in the chat that, yes, the Supreme Court has only dealt with K through 12 speech, off-campus speech. And, courts have said that you have a wider latitude of speech on campuses at the higher education level. How successful could a school be in bringing a Title VI action on behalf of their students based on social media posts? Because, yeah.
Right. So it works a little bit differently than that. The school is not bringing the Title VI action. The school is the object of the Title VI.
Okay, right,
It's the
right,
school
right.
that's
You stand
being
corrected.
held legally accountable for its failure to
Correct.
adequately respond. And the standard is, deliberate indifference, so that they were deliberately indifferent to the experience, to the discrimination that has occurred and has been brought to their attention, or that they should have known was happening, right? So it's not a low standard. I mean, it's a high standard. And there's a case from the First Circuit involving MIT. This is not the Stand With Us versus MIT case, which doesn't specifically focus on social media, although I think you mentioned that there's one instance of social media there, but where they basically was like, look, MIT took all of these steps to respond, and it therefore wasn't deliberately indifferent. But that's the determination. That's the question of whether the school has failed to follow its Title VI obligation. But taking one step back, if student experiences anti-Semitic discrimination, whether it's at an in-person protest and an encampment, or whether it's online speech by a fellow student or by a TA or instructor, that is deemed to be, by students to be extremely offensive to them. And, there was an instance at the University of Vermont where a graduate student, posted on Twitter various problematic posts, and those students, that was part of the evidentiary record that the Office of Civil Rights used to determine that there was a Title VI problem at the University of Vermont, and then the university entered into a resolution agreement. So it's, the way we thought about, the online world versus the physical world is that, it's not like the online world is in a separate category or off limits. I mean, it has certainly been determined that online activity that's, related to the university environment or community can arise to the level of a Title VI violation. I mean, at Lafayette College, I just wanted to read here from the Lafayette College resolution letter. So at Lafayette College, there were a number of Instagram posts that were problematic. And, the college had a categorical policy that it wasn't addressing allegations of harassment on social media. And, that was not satisfactory in fulfilling the college's obligation to take prompt and effective steps to address a hostile environment about which the college knows. It's not limited to conduct that occurs on campus or outside social media. It also encompasses social media, and the college had a responsibility to determine whether the social media and off-campus conduct individually or collectively contributed to the hostile environment, in potential violation of Title VI.
So, and I think, to your point, the blurring, I mean, I think that's why the Mahanoy case was such a disappointment, because it happened during COVID when students were doing remote learning. And this idea that we're going to look at this as kind of off-campus speech when a lot of people are learning, there's such a blur between social media making its way onto campus. I do want to point out one thing that I think, someone kind of raised in the chat, and this kind of brings this issue to fruition, is that the CG case where they said they are ready to exterminate Jews, that is considered a threat, right? But it was free speech. And so the school can't punish the individual for free speech, but the school can be punished, right, for not protecting the students who are going to school with this kid. In the decision, the court noted, when talking about the First Amendment right, that the substantial concern among Jewish community was not enough to support a finding of substantial disruption. So the First Amendment part, you almost have to look at it, well, you do have to look at it, right, as separate. So if someone makes a First Amendment violation, we can't go after them for First Amendment, but we can go after the schools, right, for protecting them, for
Right.
not protecting them, right?
Right.
And
Right.
so
And we're not asking the school to violate the First Amendment
Right.
in order to respond, right? I mean, the school, um, can have a social media policy that, is viewpoint neutral, that has clarity, that includes, process that applies to all students, that has proportional responses, um, and there's like ways of constructing a neutral procedural framework, um, neutral time, place, and manner restrictions that don't go to viewpoint discrimination and that aren't focused on the censorship of political speech, but that ensure that the campus environment is a place where all students can feel safe and free from discrimination. And, these things coexist in tension with each other for sure.
Yeah. Right. So in other words, what you're saying is the school cannot censor, but the school has a duty to protect. And that's kind of how we look at it. So let's talk about the schools for just a second, because we're talking mostly about public schools. Um, what about private schools vis-a-vis, does Title VI change? Does the responsibility of a school change if they're a public school versus a private school? Because, it's the government doing the action. And then there's the issue of the public school versus private school First Amendment. But what about versus Title VI?
Right. So Title VI uh, Title VI as has been enforced by the U.S. Department of Education Office for Civil Rights, gives OCR the jurisdiction to open investigations at any school that receives federal funds from the Department of Education. So that is every single public K through 12 school in the country, and virtually every single private and public institution of higher education, because any institution of higher education that participates in the federal financial aid program is essentially receiving federal funding from the U.S. government, and so they are on the hook for complying with Title VI. So there's no difference in the way in which Title VI would be enforced on a private university campus versus a public university campus. Now, the First Amendment obligations of a university may differ between a private and public university. Of course, a public university is obligated to comply with the First Amendment. In California, however, there's this thing called the Leonard Law, which basically obligates private universities also to adhere to First Amendment standards. And many private institutions voluntarily adhere to First Amendment standards, or standards that approximate First Amendment standards, and how they respond to and enforce, time, place, manner restrictions and other responses to speech. But in any enforcement action that the federal government would take under Title VI, the federal government, as a government actor, is of course obligated to comply with the First Amendment. And we were not enforcing the First Amendment; we were enforcing civil rights laws. But
Right.
any such resolution of civil rights law, civil rights investigation would necessitate an outcome that is compliant with the First Amendment and protective of civil rights and curative of any potential civil rights violation that occurred.
Makes sense. All right. I hope I don't put you on the spot with this question, but can you come up with a hypothetical or a scenario where the social media would be so offensive and so disruptive that it would give a student a claim under Title VI?
Well, I mean, I think that would go to the question of like, how targeted is it? Is it a, college instructor who's posting, very, anti-Semitic, death to the Jews or whatever, or, condoning violence or expressing, support for terrorism against Jews, or, applauding, saying, I mean, thinking about I'm from Michigan, I'm thinking about the Temple Israel incident from a couple of weeks ago. You had this obviously anti-Semitic incident, horrible event happened. If an instructor, made a post saying, expressing sympathy for the perpetrator of that, or saying, the people at Temple Israel, got what they deserved, or, something horrific like that. And, it was, a posting that was made, in a classroom discussion, or, no, the instructor posted it knowing that, many of the students in the class were following it. Or if a student organization that receives funding from the university, puts up an Instagram post, or, if there's, recurrent posts by some students that are widely seen among a broad cross-section of the community, or are, is known to be seen by Jewish students, or let's say it's posted on the school, on the University Hillel's, as a comment on the University Hillel's Instagram account. I mean, those are all situations where I think you could have social media that crosses the line in, a single post that's, so severe as to rise to the level of creating a hostile environment.
So we're going to kind of look at the who and the what, right? Who did the posting, if they're in a power position. I mean,
You
they
have
don't
to,
have
it's
to be in a
a,
power
it,
position, but it's got to be somebody who's got some kind of, for lack of the better word, influence or
well, power, it's a power, influence, or it's, reach, having reach. It's, and it's reaching students in a way that it can feel that it's targeting those particular students.
right.
They're not necessarily by name, but it is targeting them in some fashion.
Yeah. So I do have one more question for you, but I'm actually going to use the prerogative of the chat because someone just posted, is there a difference between forwarding versus creating a post? And I just want to take a moment to go back to something you said before, which is the student at my school actually removed him from a power. He was a TA, and they were able to say, the school's not going to pay for any of your activity. We're not going to pay you as an employee of the school because of what he did. The reason I'm bringing that up is because he actually kind of retweeted the post or reposted the post versus created it himself. And so I personally, I don't have any skilled knowledge in this, but I don't see a difference. But I'm wondering, do you see a difference between someone who forwards an anti-Semitic post and someone who actually creates the anti-Semitic post?
Well, in terms of the university's response to that post, I don't see a huge difference. I don't see a difference there, because the point from the standpoint of the university is to determine whether this post is contributing to, or creation of a hostile environment. So it's going to be less about who made the post and more about how that post is being experienced by students. Now, in terms of a disciplinary, response, I mean, that's more outside the Title VI context. But I think that if it's a post that's, protected by the First Amendment in the first instance, then it would certainly be protected by the First Amendment by anyone who reposted it. And so, I don't think that really changes materially the analysis.
Yeah, and actually, when I think about it, there's like law for that with defamation, right? There's some defamation cases that talk about the reposter. Last question, and
Right.
because we want to leave time for. So, as a faculty member, if a student comes to me and says that they are frightened or upset or disturbed or unable to focus because of a social media post that a classmate posted, what should I do? Like, who do I turn to? What should I do? What steps should I take?
Yeah, I mean, you can, I mean, you have the ability to connect that student with the school's equal opportunity office. I mean, where every school has its own set of policies and procedures for considering complaints that students bring, but also as a concerned faculty member, you could certainly call this incident to the attention of the university, and they could look into it, not only with respect to that student, but with respect who might have been the student who came to you, but to look broadly at how the particular incident might be affecting other students. I mean, in OCR, because we were in OCR, it was an administrative enforcement agency. So, it wasn't like in a lawsuit where, the court is going to consider the complaint and allegations of the particular plaintiff. In an OCR investigation, we would look at an individual complaint, but it could also be the springboard to broaden out an investigation to look at how particular speech is affecting other students, either the particular speech that's being, that was the subject of the complaint, or other instances of anti-Semitic discrimination or other types of discrimination that might occur, and to determine whether the school is adequately responding. Right, Title VI enforced by OCR is a legal accountability measure for schools, and when schools are failing to fulfill their Title VI obligation to protect the civil rights of students, of one group, oftentimes, it's the case that they're failing to do so with respect to other groups. So, we might open an investigation into anti-Semitic discrimination, and then discover that, well, there's actually evidence of race discrimination, and so we would expand our investigation to look at that. So the point is that bringing this kind of incident to the attention of schools' equal opportunity office, Title VI office, Title IX office, gives the opportunity for the school to determine what's happening with respect to this one incident, but what is happening potentially more broadly that needs to be addressed and responded to.
That's super helpful. And that's a good way for us to end our conversation. So I'm going to now turn it over to Rafe and Stephanie. Thank you, Matt. I actually learned a lot. So thank you for this.
Oh, great. Well, thank you. Thank you.